Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can you sue a district attorney? The short answer is almost never, and the reason is a powerful legal shield called prosecutorial immunity. This concept is designed to protect prosecutors from being constantly sued by every person they charge with a crime. The thinking is that if DAs had to worry about being sued for every decision, they would be too scared to prosecute difficult cases, and the justice system would grind to a halt. But this protection isn't a single, simple rule. It's broken down into two main types. First, and most importantly, there is absolute immunity. This is a nearly unbreakable shield that covers everything a prosecutor does as part of their core job of prosecuting a case. This includes the decision to charge someone, what charges to file, what evidence to present in court, how to argue the case, and whether to offer a plea bargain. So, if a prosecutor charges you with a crime and you are later found not guilty, you cannot sue that prosecutor for their decision to bring the case against you, even if you lost your job and spent a fortune on lawyers. This absolute immunity protects them from lawsuits even if they made a mistake or used poor judgment. The second, weaker type of protection is called qualified immunity. This applies when a prosecutor is not acting like a lawyer in a courtroom but more like an investigator or an administrator. For example, if a prosecutor gives legal advice to the police during an investigation before charges are filed, or if they make statements to the press, they might only have qualified immunity. To sue a prosecutor for these actions, you would have to prove that they violated a clearly established constitutional right. This is an incredibly high bar to clear. You have to show that any reasonable prosecutor would have known their actions were illegal. So, what about truly wrongful acts, like a prosecutor intentionally hiding evidence that proves you're innocent? This is where things get extremely complicated. While courts have said that intentionally hiding exculpatory evidence is a serious violation, the doctrine of absolute immunity often still protects the prosecutor from a civil lawsuit for damages. Your remedy would typically be to appeal your conviction, not to sue the DA personally. In extremely rare cases, where a prosecutor acts completely outside of their role, like fabricating evidence during the investigative phase, there might be a tiny window to file a lawsuit. But these instances are the exception, not the rule. The bottom line is that while it's not legally impossible in every conceivable scenario, suing a district attorney for actions related to a prosecution is one of the most difficult legal challenges in the American justice system. The wall of absolute immunity is very high and very strong. Thanks for watching. If you found this information helpful and want to learn more about how the legal system works,